we're going to get started. Thank you guys for all coming out today. You know all of us here. We've got name tags up front if you don't know us. I'll give a kind of a quick highlight of how we got to today, and then we'll jump into either we can answer specific questions or we can kind of go into high level, a summary of the operating agreement, whatever you guys are thinking, because this is for you. So in, I think July officially was when our moratorium was adopted, and what we did that for was to renegotiate our operator agreements with Crestone as well as Anadarko and Extractions. We don't have an agreement with Extractions or Anadarko right now, but we wanted to create one, as well as potentially look at updating our code if in that process we realized that there were things that we hadn't included 3 years ago, 4 years ago, that may be relevant now. So when we kicked off that process, we started working with, we had 2 board members and some staff working with our oil and gas attorneys and working with Crestone to start talking about what we wanted to accomplish in the operating agreement, and as far as gaining citizen input. So when we did this moratorium, or not moratorium, when we did the negotiations, I think in 2015, the first time, we had one meeting for the public to come to. You could come up and talk for 3 minutes, and we said, what do you guys want in an operator agreement? It was a long meeting, and it got really specific, and it was hard for us to really address what residents wanted at that time, because we would get all these really specific, I want 100-watt light bulbs pointed down at 30-degree angles, and then going into negotiations with a list of specific things is a lot harder than saying, here's the problems we want to solve, and then trying to work with the operators in the town on what solutions we have. So this year we did it differently, which you're probably all aware of. We started out, we did the video to kind of introduce what we were doing to get citizen feedback. We had a town survey, which I think about 450 people responded to. So you guys could tell us kind of high level what you were concerned about to help us guide those efforts in our negotiations. And then we also did the face-to-face sessions. That was a handful of weeks ago. So we tried to do all those different avenues to give you guys all whatever you felt comfortable doing and you had the time to do to give us feedback. We were trying to cater to that instead of the more structured approach that we did 3 or 4 years ago. So kind of high level, that's what we've been through the last 4 months, 4 or 5 months. It's a lot of work behind the scenes. But you guys knew we started a moratorium, and then you kind of see these things pop up for citizen engagement. But we've been working really hard behind the scenes to incorporate what you want into the operator agreement. So that's how we got to today. And once we got more finalized documents, we reviewed them on Tuesday and then asked them to be public so we could get feedback before a meeting. In the past, again, we've only gotten feedback the day of a meeting and vote. So we're trying to give us a little bit more time too to listen to you and adapt to what you're saying before we vote on the agreement. What do you guys want? Do you want to have any questions, or do you guys want to just start with some questions and we can kind of go with the flow?
So you can see if you can hear from out there, otherwise the microphone does work if it's on the table.
Okay.
I think the microphone will be instrumental in the recording and making that available to others. So please, when you have your question, please come up to the microphone and state it. Having said that, the only caution I will give to the audience is that we as a Board of Trustees are also a party of the quasi-judicial process around the ACME Type B application that has been filed by the town, or at the town, by Crestone Peak Resources. So we cannot discuss the peculiarities of that particular application. Is that a head nod from our oil and gas attorney? Anything else you need to clarify?
Yeah, since you are in a quasi-judicial capacity, you can't discuss ACME.
However,
today.
You guys can, or can we still ask about it?
So if you ask a question or you give us feedback about that particular pad, what it does is it constitutes testimony, and we can't hear that testimony outside of proceedings that involve the other party in the Type B application. So the answer there is no. Please phrase your question, and it may take a bit of originality on your part, and we'll play this game together about phrasing your concerns in the context of the operator agreement. and any specifics that are mentioned there, and that way we can discuss freely.
Okay, so yeah, whoever wants to come up and start with some questions. We are recording this, it's not live, but it will be put online like other meetings, so if the public couldn't make it today and wanted to see a recap of what we talked about, they can. So yeah, if you guys want to sit in the front row, if you were in the queue for asking a question, feel free, or you can hop up, whatever you guys want.
Okay, I have 3 questions. I'm Siobhan Blades. I live here in Erie. I'm really confused what's happening here today. I've read a lot online. I've been getting texts, and it's just very confusing. That's the first question. The second question, since we do have a moratorium right now, why does this feel like it's being rushed? And then the third question is there something forcing this conversation to happen today? Is there some sort of legality that is requiring this to happen now? So those are my 3 questions.
Do you guys want me to start or answer these pretty quickly? So what we're doing today is trying to add one more step between when we see a document and when we vote on it in public, like I explained in my intro. So last time we only heard feedback from our residents during public comment the night we were voting on it. So that puts a lot of pressure on us to, if we do hear something that's really creative that we didn't think of during the process and maybe want to incorporate in the agreement, it's really hard for us to do that on the night we're trying to vote on it. So if we hear things from you, suggestions on things we want changed or added to the operator agreement that we think we agree with and we think we could work with Crestone on, then we have a couple days to work with them, and they're committed to working through ideas quickly to try to have an agreement updated. The Tuesday date when we were doing negotiations, the November 1st date had come up. I didn't remember it. I was focused on details. Trustee Deacon was one of the negotiators with me. So Crestone put their plans on hold for vessels, I think in May or June, when we first brought to their attention that we would want to try to move that site. Right? That's in the center of Erie. They had talked about 43 wells in the operator agreement. When we did the old operator agreement, we weren't expecting 43 wells. At the time, 7, 8 wells were what was going on pad site. So we went to them saying, we heard during the election that residents have concerns with that site, which is right by County Line and Erie Parkway, so just southeast of there. You would see it right off of County Line as you're coming in. So we had approached them at the beginning and said, we want you to get creative, look at any alternatives you can for that site. So they were starting their application process with the state. They paused that. So May-ish to now, how many months? 6 months. They have delayed their process, but they have their own timelines and when they want to get sites drilled so they can maintain all their obligations to their customers, shareholders, bondholders, whatever. They are now at a point where they need to get moving with the state process for both the vessels and the Acme site. They've already been submitted, so the election results will not affect either of these sites. They've already started the process with their own pause, and they need to keep moving to meet their deadlines. So for us, we're looking at voting on it Tuesday because we want an agreement. We want these higher safeguards that we're getting. And if we don't reach something by November 1st, there's a really good chance that they're going to go submit the 2 sites separately, and then we get nothing. So it's not comfortable for anyone, right? It's not great, but it's kind of the scope we're living in. And I don't want to play chicken with them and say, okay, are you really going to submit your applications November 1st? I don't want to risk it because I think we're getting some wins for our residents in here. Sorry, I have a cold, so I'm like, I can't breathe out of my nose, so I sound exasperated because I'm trying to talk and I can't breathe at the same time, so I apologize if I sound very out of breath. So I think that answered your 3 questions. Okay. Yeah, anyone else add on?
No, I have a different question.
Okay. Do we have any representation from Crestone here today?
No.
No, I asked them if they were going to come to this and they said no.
Okay, thank you.
I just wanted to ask, one of our residents wondered, has anything changed on this operating agreement since last Tuesday's meeting?
Yes.
Just address that. Thank you.
I don't have that email. Did any of you have that email before?
Well, yes.
Okay.
So there was an original draft of the operator agreement posted on, was it Wednesday?
Yeah,
Wednesday.
On Friday, we posted the updated.
On Friday, an updated agreement was posted that took into after the executive session on Tuesday. The first was one around a clause in the operator agreement around neighborhood meetings, that the first draft only included some verbiage about a lockbox containing 3x5 note cards, that the operator agreement there has been updated to include an interaction with residents where questions can be asked by residents and answers be delivered by Crestone. The second is a clause about the use of Gibson D822. That is the drilling mud that was used at the Pratt and Waste Connection sites that was linked to all of the odor complaints from those two pads. I still have feedback on that. That my request plainly is that Crestone do not use Gibson D822 period within the limits of the town of Erie. There's language in there that says they will do their best, but there are some loopholes that I find unacceptable in that language about if, for example, it's not financially feasible or an alternate product is not readily available. So if it's out of stock, then they can go ahead and use Gibson D822. So that is something that personally I will be pushing back on in my feedback on that. And the last one is around dispute resolution. That I had asked, and we had communicated to Crestone that what we really wanted is if at any point the town had submitted to Crestone a complaint around whatever issue it was, whether it was noise or odor or traffic, that they could not start to drill at a new site until that dispute was resolved, up and through and including mediation if necessary. Anything to add?
Nope, those were the three.
Thank you.
So we had asked for the three things, and we got, other than what Christian kind of mentioned with the language with the mud, I feel like we got a good response back from them on being able to modify our request. Were you going to add something a minute ago? What next? Anyone feel free to come on up.
I did submit this by email to the board. I have lots of questions. And cut me off at any point. So we have a company, Crestone, who wants to openly work with Erie, but shows us from the get-go that violations of the town code meant nothing to them. How much was the initial fine for the violation? Do we have?
So they haven't been issued a fine yet because of the litigation. I believe it's around $3,000 if we win.
$2,650.
Okay. So instead of paying that violation, we bought it and created a lawsuit against it, correct?
Yes, they filed a lawsuit in the Weld County District Court
Okay.
to hold up the municipal court prosecution.
Okay. So not only did they not pay it or pass it on to a responsible subcontractor, we're now going to reward them millions of dollars in concessions under this new OA. Is that about right?
So I saw some chatter on this, and a resident who reached out to me to ask for clarification yesterday. We aren't giving them millions of dollars of concessions, so they estimate the number. I think the Daily Camera statement, where I think a lot of this word came from, I know what's going on, so it made sense to me, but trying to read it from outsiders looking in, I think it unintentionally, intentionally, who knows why, it made it sound misleading, at least from my perspective. So Crestone estimated their approximate cost to move the vessel site to be about $3.5 million. A lot of different components that go into that value, some cost savings and then some cost uppers. And we have language in our agreement that says to help offset some of those costs, we will not charge them for the pipeline crossings. And the way the Daily Camera wrote it, it sounded like we were giving them $3.5 million of concessions in exchange for their cost of $3.5 million, and that's not the case. So the state land board values pipeline crossings or right-of-way crossings at $5,000. We haven't finalized our agreement, but we're looking at 10 to 15 crossings for their pipeline to connect their sites to the hub. So you look at that 15 number times the 5,000, you're looking at $75,000 that we're waiving in revenue. in exchange. I mean, right, and there's pros and cons for both the town and then, and other parts of the operating agreement, but that numbers piece, those are kind of the two big numbers that they're gonna be spending and that we're waiving.
So it's waived fees.
Yes.
Okay. What is the status of the lawsuit currently? Have we won, lost, dismissed? What are we seeing?
Well, the lawsuit is currently set to go to trial in January 14th, 2019. By the way, I'm John Sullivan, the special counsel with Sullivan Green Seat. I forgot to introduce myself before, so I apologize. So we're set to go to trial. The court did rule in favor of the town on what's called a summary judgment motion as a question of law, that the town was not preempted from enacting the odor ordinance that it enacted by the Colorado Air Quality Control Act. So if we go to trial, if the town goes to trial in January, you're going to be going to trial on issues regarding the constitutionality of the ordinance. In other words, is the language, in one aspect of that is the language of the ordinance too vague to be enforced? In other words, the defendant doesn't get adequate notice of what conduct is prohibited. Crestone has also said in the lawsuit that the ordinance was enforced against them arbitrarily. In other words, they were singled out and other people were doing the same thing, or there were other odors that had nothing to do with oil and gas that should have been sanctioned or something like that. And that would also be their defense to the case in municipal court. Right now, we've been working with Crestone. We asked for an extension for pretrial motion deadline that will expire on November 12th. That's the new extension date.
So this was also mentioned, I think, in that same, maybe in that same article, but did they agree to drop this lawsuit if we sign this OA?
Sure. The component of this OA that deals with the issues in the lawsuit is the odor management plan. So that's Appendix D to the operator agreement. And Crestone has agreed to abide by that odor management plan under this agreement. The odor management plan has been reviewed by outside consultants for the town who approved it in its current form. And so if this agreement gets adopted, it will resolve the litigation. We will file pleadings in the court. Crestone will dismiss its case in Weld County District Court. The town will dismiss its case for the municipal code violation.
Well, under the OA where they mention the new odor management plan, I think that's what you're referring to.
Yes.
What are the consequences and clear fines of that plan going to be? And who's going to monitor that? Is that a town function? Is it based on the residents filing complaints like we've been doing? And who's going to monitor that new ordinance that they have now agreed to?
So maybe I could rephrase it as a different question, or a different series of questions. After we sign an operator agreement with Crestone Peak Resources, will the current odor ordinance still be in effect?
Yes.
If Crestone, if as previously done, if several residents note and report odors from the Crestone Peak Resources operation, will they be eligible to receive a citation under the current odor ordinance?
Yes, they could still receive a citation. The way this OA is worded, if they are in compliance with the odor management plan that's part of this agreement, then it is a defense to a violation of the odor ordinance. So their defense would basically be to show we were in compliance with the odor management plan.
Which is clearly what we've been fighting for years, is that every time that we have issued a complaint, we get that response. they're in compliance. So, from the state organization. And if Crestone has said, well, this is what our odor plan should look like, we're just going to agree to this? I mean, do we know, can we take it above and beyond maybe what the state regulations are?
Well, that was part of the idea in the odor management plan, and that's why we sent it out to the outside consultant, so they could look over that plan, tweak it, which they did, added some language to it, so that the town wouldn't be in the position of having to take Crestone's word for it. And the idea is that this odor management plan uses best available technology to manage odor.
So we have an outside consultant working on this OA and the technology behind it.
Yeah, and I'll add to that point. This effort was drastically different than our last operator agreement. The last one, we kind of worked in a vacuum. It was our attorneys and me and Mayor Pro Tem Gruber at the time negotiating. And this time, our interim TA was super involved with us. So we had kind of the staff plug-in, we had our attorneys, we had the board representation. We consulted with CDPHE and some of their staff. The COGCC connected us with a lot of their technical experts in both like odor management and some different areas we're trying to address in the operator agreement, as well as we have an outside consulting company now that's going to help us, one, do oil and gas application reviews and air quality monitoring. We want to do sound monitoring, et cetera. And that's a newer consultant we found. It's not Pinion, it's a newer company we're working with. And then we also looked at a handful of neighboring municipality agreements, including Tacona, Brookville, Board County, I think Thornton, maybe a few others, to make sure we were incorporating as many of the BMPs that other municipalities have adopted as we can. So we definitely went out with as many resources as we could to get review on what we're doing, to get advice on what we could manage, or really just to make it as robust as we could.
I think you answered this previously. The deadline for signing this is based on Crestone's need to get this accomplished before November 1st. Did I hear that correctly?
So that's the date they have set and when they want to keep things moving forward, whether we have an agreement or not. So to meet their own dates of when they've booked equipment, et cetera, et cetera. I don't know the details of it, I just know they have plans that go 1-2 years out.
So let me work on the next one carefully, as Christiane suggested. Maybe I can, maybe I can't. If they want to increase wells at another site at this point, do they have to have that site re-permitted?
No.
Would a Type B application submitted by any operator have to be resubmitted if the well count was doubled?
The agreement deals with the location of the pad. It does not say anything about the number of wells that can occur at a particular location. That would primarily be a function of mineral rights, ownership, drilling and recompletion technology and things like that.
Well, wouldn't that be shocking to any town or community if somebody wanted to come in and got permitted for one well and it turned into 100? I mean, is that how it works?
The town wouldn't control how many wells they're allowed to have. That would be at the state level.
I know, but I'm from an understanding. I know that you couldn't or may not have the right, but if you're working on an agreement with an organization and they have the right to double the well size pad, triple it, quadruple it, wouldn't you want to know that's happening for your community's sake?
I know in our agreement, in our meetings, we have if their plans change, they're supposed to notify us before they submit their forms to the COGCC. So I think that conversation would happen at the staff level. I don't think we had discussed limiting wellheads per site. That's something we can ask them about. The number in there, right, so there's some certainty to residents.
The submissions, there's a whole bunch of submissions that Crestone has to make to the town that identify all kinds of things like site disturbance, grading, water quality issues, and that's where this would be addressed. And the same best management practices would apply to a site, an agreed upon site under the OA, regardless of whether it has 1 well or 20.
Okay, so I'm looking at it strictly from a resident standpoint.
I understand.
Okay, and I'm just asking that from that standpoint and how my town is going to protect me from something like that happening in my backyard. So I don't know if that's something that can be included in an operator's agreement. And then my final comment or question would be, does every industry out there require their own operator agreement, or can we standardize these agreements so that we have a town agreement, and then they have to agree with what we want? I kind of feel Erie is truly behind the 8 ball in a lot of these negotiations. I know our hands are tied at the state level to a certain extent, but it always seems to be that it's in the favor of the oil and gas industry. So, I don't know.
Can I answer that one?
Well,
An answer, but
I mean,
provide comments.
is it possible to have a standardized operator agreement?
So our goal was to take the Crestone agreement and then use that for Anadarko and Crestone if they would agree to it. But the other concern you stated, which is one I think all of us share, is, right, we all wish we had the upper hand and we wish we could say, Crestone, here are the 5 things you have to do or you're not drilling in Erie. We don't have that ability. We will be sued, and right now we will lose under current state law. There may be a Boulder County out there, right, that has a lot of money that's willing to take that risk and spend the money to just make a statement, but we're not in that position. We don't have that much money to just throw at. We won't call them frivolous lawsuits, right, but lawsuits that we feel like we have a really bad chance of losing. So in our code, what we did last was we tried to make some different options, right? So there was like the type A, which I think mirrored our operator agreement. So that was kind of our, if you're going to be in Erie, we want you to follow these rules. And it mirrored our original operator agreement. But we couldn't have that as the only option because we were asking for things above and beyond what the state required. So that's why we had to have a type B also, which was, we could include some extra things, but any operational aspects we couldn't address because that conflicts with state law. So right now we do have a preferred method, and it makes the process quicker for operators in our code that they ultimately have the choice. I think we all share the same feelings. We wish we could have more control.
And I'll add to that a bit. Back when Crestone and the town of Erie negotiated their operator agreement in 2015, that was held up by other municipalities as the gold standard. And Broomfield County used that, and Broomfield used that, and Boulder County used that. And now we again, as we're negotiating with Crestone 3 years later, have looked at Dacona's regulations and Broomfield's regulations and Boulder County's regulations and attempted to iterate on those. So in a way, yes, it would be very nice for a standard operator agreement to be in place, but we very much recognize that our learning as a municipality grows every time we see another municipality go through the same process. So we very much would like to be adaptive and iterative as we negotiate operator agreements with subsequent operators.
Okay, thank you very much.
Any other board members want to address any of their questions before we move on? We can talk about. Okay. I'll make sure I'm not.
I'm Liz Fisher. I'm used to seeing you folks at the boardroom, and I think that's where we should have been meeting today. And I just have some general comments to make. I found it, just my nerves are shattered meeting in this room. I'm incredibly nervous. I found it incredibly demoralizing and frankly insulting to have to pass access to a security check to enter this room and talk to my elected representatives. I remember in 2015, the stakeholder meeting that you referred to, Mayor Carroll. I was there, I participated in that. That was held at Town Hall, it was recorded, public record. And I was also in attendance for the public hearing that preceded the operator agreement, 2 readings. And now I read this morning that the operator agreement is scheduled to be voted on in a couple of days, with no public hearing, no first and second reading. This, I guess, is what passes as a stakeholder meeting. That and the other informal community engagement sessions where a few people at a time talk to you in private, none of that was made public. This is not okay. We're getting short shrifted. We're not getting due process. And I feel you've broken trust with us. You're not really upholding the promises you made to us to hear our voices. And I would urge you to take the operator agreement off the agenda on Tuesday and allow for due process. And that's really my main concern and the main point I want to make to you today. I hope you'll consider that. Thank you.
So maybe a follow-up question then for town staff. The agenda for Tuesday was added to the agenda of a 5:30 meeting for town administrator selection process. And I've got deep reservations about that as well. I share those concerns. One of the most important aspects that I don't see on that agenda is a public comment section for that meeting with a specific time.
So the board sets the agenda, so that would be a question for you guys to decide if you want the agenda changed, updated, adjusted. We can do that, I believe, up until 24 hours prior to the meeting. So that's a board question and a board decision. We did already on the 30th have the town administrator search with Ron Hallfield coming, so that's from 5:30 to 7:30. So that's up to you guys of what you want it to look like from 7:30 until, but we have to start that meeting since it's a special meeting by 5:30 and have that first executive session first.
Right.
But you guys set the rest of that agenda.
So looking at the other folks on the dais, was there a majority board decision to put the vote of the operator agreement on Tuesday's agenda?
I don't think we officially asked.
So
I put it on officially with Beryl when we were
Okay.
looking at the agenda. If it ends up failing because people aren't ready to vote, then it ends up failing. Right, we are up against a wall, and I know.
Right, so I'm going
I mean,
back
it's
to
something
the-
that you guys can discuss.
Well, I'm
today
going
and
to
tomorrow
the
with all 7 of you.
procedural question, putting an item on the agenda, does that require majority board support?
The mayor or for, I mean, yeah, the mayor
Okay.
or 4 of you.
Okay.
Yeah, should decide.
All right.
And like I said, I don't want to play chicken with them, right, and say, we need 2 more weeks, and so, right, and just see if they're gonna submit 2 applications or not, because I feel like we're gonna lose. We're between a rock and a hard place. I get that. I'm not saying this is a great, perfect solution or setting or.
Are you asking about adding public comment to the agenda,
So-
or are you
Sorry, I
asking
thought that
about
was
changing the order of the
public comment.
agenda? What are you asking about?
Mayor, could you please work with the interim town administrator to add a public comment section
Yeah, I thought there
To the
was,
meeting?
that's my bad.
at a specified time.
Yeah, so
For me,
7:30.
is a very important detail there, that residents need to be able to plan their evenings so they can show up to a meeting like that and provide their public comment.
Yeah, I was assuming it was just there because it was a meeting, so we'll add it. We have our first exec 5:30 to 7:30, and then we'll start our next meeting, which is only oil and gas, at 7:30. So you don't need to show up at 5:30, you're gonna sit there for 2 hours while we're in the room.
Will public comment begin at 7:30 or our executive session?
Why don't
I
you
would
let
say-
us work that out and then we'll reset the
Alright.
agenda after we talk.
So it seems the concern is,
We can talk to the details.
the concern is voting on this to preclude, assuming it passes, to preclude Crestone from filing applications for vessels and
To continue what they've already filed.
to continue
Right.
to, so.
And without anything that we get any agreement now, right? Because they would just move forward and we get nothing.
But how do we, when we have a moratorium in place at this juncture right now? Should we need 2 more weeks or 1 more month? What can they accomplish in that much time that we couldn't reverse by executing this in that month?
That's a question for them. I think once they start their applications with the state, they're not gonna want to pull them back, right? Because that's just gonna set them back another couple weeks or when.
So the state applications, at that point, then there's no way to even execute this thing because the sites that they have applied for through the state will then be things that are in here and have to rewrite this thing anyway.
No, so what they're prepared to do on November 1st is either move forward with what's in the operator agreement, right, and making sure those plans are moving forward with the state, or if we don't have an operator agreement, submitting their original plans for Acme vessels with no operator agreement and no extra PMPs, et cetera. I don't know if I'm.
No, I think you're saying, or as I'm understanding it, it seems like they're really holding our feet to the fire with this one. I don't know why the timing has turned out the way it is. They've been, maybe their minds gracious to let us do this long. To me, this is pretty new. I didn't see these things until last Thursday. And I would like to see if you could ask for 2 to 4 weeks longer to say, give us some more time to digest this. Because that's one member of the board I would like to digest this.
We can ask again, we asked them last week, and we got it pretty firm. November 1st, we're either moving forward without an operator agreement, or we're going to move forward with one. So I think it's, if you want to take a risk, and there's 3 other of you that want to take that risk,
I don't want to set back the agreement. I don't want to set back all the work.
Right.
that's where we're at, right? We either have to believe them, or we're going to call their bluff. And we risk not having an operator agreement.
They were firm, like the mayor said, they were very firm in their dates, so.
Trust me, I wish I could have 3 more months to look at this. I'm not choosing their side to choose their side. I'm looking out for the best interest of the residents, and I don't want to play chicken, because if we don't have an operator agreement, we won't have the additional leak detection, air quality monitoring, sound monitoring, and I don't want to lose that. So,
I wasn't at the last, for information, the audience, I wasn't at the last Board of Trustees meeting, so I didn't get the sternness of that date.
and they wanted us to vote on it last week, and we said no, we want to have the public read the agreements and engage. Because at that time, we hadn't made documents public, so.
Can I just add something about what the agreement says? It's in the November 1st date. What Crestone is reserving the right to do is submit its Form 2A to the Colorado Oil and Gas Conservation Commission. That's the oil and gas location assessment form, and that initiates a process with the COGCC. And they wanted to reserve the right to do that on November 1st. They don't read the agreement to say, if you don't sign it by November 1st, the deal's off the table.
Say that again?
No, that's
Oh,
what they
okay.
told us on Friday.
Okay, I'm just looking at the agreement itself. Okay.
That's what they've communicated.
They've
Fair enough,
communicated that,
yes.
okay.
So if they,
Do you want to let these people talk that are sitting here maybe and like,
Sure.
you guys will still have the chance to talk about this on
I mean,
Tuesday.
we can talk about it.
Yeah.
Come on up.
Yep.
Yeah.
There's a queue.
got a question relative to.
Write it down so you don't lose it.
Don't forget it. Go ahead.
I'm sorry, there'll just be one quick question, I got to jump line while we're talking about this. David Lawton. So if they submit their application on November 1st, we say no, we want more time, they submit their application on November 1st. 2 weeks later, we come to an agreement, can they amend or change their application?
I think they can, but the problem, from what we've been communicating, is right, they've gone as long as they can with delaying moving either of those sites forward to meet their schedule. So if they go 2 weeks, we get an agreement then, now they're restarting over that, so now they've lost 2 weeks, and they're potentially missing deadlines and obligations. So that's where the rub of the date comes in, is they have scheduled meetings.
I think that's also compounded by pending litigation with Boulder County over the Boulder County CEP. They won't be drilling there anytime soon. So Erie is kind of the next frontier.
And the Acme site right now is being processed by the town under its UDC oil and gas regulations as what's called a Type B permit. The Acme site is not subject to the current operator agreement. The vessel site is, but the vessel site would go away under this agreement.
Then my question was, so we want more time, they say no, they submit their applications, then 2 weeks later we come up with something everybody can live with, can they then resubmit or change their application?
Yeah, the answer is
Can
yes.
they?
It's
The
just
answer is
will.
yes. Will they? Can't say because I haven't asked them that question.
Okay, come on.
I have a few questions. One that just popped up. You said you did a survey 4 months ago.
The survey was, we kicked off all the efforts 4 months ago. The survey.
Where did that survey go?
Second week in September?
Who did that survey go to? All we received was a letter saying it was going to happen.
So this was an online survey we did. It went out to the town's notified me list. I think if you were signed up, do you have to be on the oil and gas list, or did it go out to anyone signed up?
I think that one was
Okay, so anyone that was signed up for
How would you know
notification.
you need to sign up for the site in order to be surveyed? I mean, if they can send us a letter, or they can send us, you don't usually send messages about BOT meetings, but how would we know that there's a survey? When you send us a letter saying this is happening,
What letter are you talking about?
just
Preston.
Okay, Preston, so that's not from the town.
Well, I realize that, but if that can happen, why can the town not send out something that says there's a survey online and this is how you have input?
There's nothing saying we couldn't. We sent it out for notified me, we put it on our website. I think maybe it got put in the Daily Camera. Hadn't thought about a global mail.
You did face-to-face with some people, or
Residents.
how was that decided?
At the beginning, we said we wanted to engage residents differently than we did last time. And so we thought,
I'm sorry, you did what?
we decided that we wanted to engage residents differently than last time. The environment on oil and gas has gotten a lot more hostile over the last couple of years as compared to the first time we did the operator agreement. So we've heard from a lot of residents that come into a board meeting speaking for 3 minutes on a recorded stream with people in the audience videoing you on their cell phones is scary, and that a lot of people won't do that. So we did the survey, we had a specific oil and gas email account we opened up, and then we had the face-to-face interactions to try to give people whatever option they wanted to communicate with us outside of just normally emailing us or seeing us.
How was face-to-face set up? I still don't understand how you pick to do face-to-face with.
So
A resident would register it. A resident gets to say, we want to meet with you. The board members didn't pick residents. Is that your question?
Well, I just don't know where it came from.
Yeah, a resident could say, hey, I want to come in and talk with you. That's what.
We posted 4 sessions, and then just like the survey notifications, it went through the Notify Me system, which I believe you have to opt into to get. But once you opt in, you get notifications about all kinds of stuff happening in town, and that went out with a link to sign up. And there were a variety of times, and it was all the same location, but all a variety of times that you could pick to meet with whoever of us was there. So some people in the audience here chose to take advantage of that.
Another question I had is, this probably doesn't deal with the city, I don't know, the zoning laws, because where they're putting them in is low-density housing, but it's industrial now. Nothing has to happen to change that before industry.
That's the age-old question, and that's, I think, the root of a lot of the conflict with oil and gas, right, is that you're doing something industrial in the residential area. It's like the root of every discussion. The state has allowed that. That's the only industry that gets to local municipality zoning for their operations. So
Is that the same thing as changing from 1,000 foot setback to 522 feet setback, which from our house would be literally almost in our backyard, and you're going to the house? So is that the same thing that the state says you can do it wherever you want to do it?
the state sets setbacks, and their current setback is 500 feet to homes, and is it 1,000 feet to schools or high occupancy buildings?
It's called the urban mitigation, urban mitigation area, I think.
So the state sets the minimum setbacks as well.
And the way the state setback system works is, once you get the operation within a certain distance of occupied homes or high occupancy buildings, the amount of mitigation that an operator must do to curtail the impacts increases. So 1,000 feet, you're triggering one thing, so is the large scale urban mitigation area, and then 500 feet triggers another set.
And I think also that as a resident, we felt there was a short turnaround and that there was a lot of closed door communications for oil companies that were not with the residents. And we wondered why that is that they had so much input into it and we did not.
So negotiations, I believe, are always, we treat them confidential no matter what the negotiation is for, whether it's for a land deal, a commercial deal, we always do those in exec session. I think just for confidentiality of the agreement. We felt like we were engaging with residents in numerous channels to get feedback.
Also, property values, is there any kind of retribution or anything? Because property values, as we learned in Commerce City, plummet when you put in however many wells. Is that anything that the city, I mean, I know we're going to make a lot of money on it, the city is, but you wonder with the property owners, you know, whether there's a health issue, whether there's a noise issue, any of that, property values are going to plummet. Is there any thought given to that, or the oil companies?
We certainly don't have a say in that, of course.
Why not? Aren't you here to protect the residents?
Well, like we said, there's only so much regulation as a town board that we can put forth. I mean, it's unfortunate, none of us like this.
I think her question really is about compensation.
Property values or compensation?
Why?
Is
I
that
know
part of
you're
your
saying
statement?
none of us want this.
Right.
How many of you are having it 500 feet from your house?
I will say I did suggest that there might be a way to compensate residents that live nearby, so I have brought that up. We haven't talked about it since then. I also have seen studies, and if this can be argued, that's fine, that not during the time of the drilling. Now, are you backed up to, so that would be right now kind of like open space?
Right.
Okay, so there are some studies that say that property values are actually greater when, not when the drilling or the fracking is taking place, but even if there is a pad there, that the property values in Erie should be greater if you have a house that is similar to another house that backs up to another property. I'm getting confusing here.
Yeah, you know what I'm saying, it's going to be greater.
Not during the process. So I understand
But
that.
after the process, the house will be greater value when they're pumping.
It's a little bit different situation. Many of the properties that back up to drilling sites, when they're not in the process of drilling or fracking, have greater values than a similar property that backs up to a home. I'm not suggesting that you should look forward to greater property values, that has been.
Ours is not open space, ours is
Correct.
yeah.
And again, I have suggested, and I think there are ways to compensate residents that do live nearby. I think that can be done with some of the taxes that we receive. So.
My last question, which I'm sure the all wells are thinking about, is how is the traffic going to be handled on Highway 7? I mean, I just bringing in all the pipes and the trucks and the, how is that going to be held? I mean, do you have a plan for that, or? I mean,
There are existing town regulations that deal with traffic management plans. And I have not reviewed the traffic management plan that was submitted for the Acme Wellhead. I don't even know if they're at that point in the town's process yet.
So like when you're coming down the road, that you're going to address the issue of how you're going to do this.
Oh, yes, and the agreement would address it too, because one of the submittal requirements is a traffic management plan.
So that is in the agreement?
Yep, it is.
What is the plan then for how they're going to address getting all these trucks in and out of Highway 7?
Right, so we don't dictate specifics in the agreement because things change over time. No, we say that you have to do it, submit a traffic mitigation study and plan. So that's something they'll submit to us, and we have to review it and accept it. And if there are any disagreements on whether or not they're actually sufficiently going to be mitigating traffic, then that goes, if we're in the agreement, right? Not just in normal operating plan. Then we'll go into a conflict. No, it is. The specifics of you can only have trucks from midnight to 6 isn't listed in the agreement. But they have to submit a plan, we have to agree to it, and if we don't, we go into a conflict resolution phase, which is defined in our agreement, which could end up in mediation if the both parties can't agree. We brought this up with Crestone, and we're asking them to get truck traffic outside of rush hour or overnight hours, and that's something they want to do, right? It's easier for them and it's cheaper for them because then their drivers aren't sitting on the road in traffic.
So it will be in the middle of the night?
Outside of like the 7 to 9 rush hour, we talked about night, it could be middle of the day. There's no specific plan now, but they don't want their drivers sitting in traffic any more than we want their trucks sitting in traffic.
And I don't want to hear the pipes and stuff in the middle of the night, so I hear you. Okay.
So, sorry, before I let you go,
Yes.
back to this topic of compensation, as an affected resident, would $10,000 make you happy?
Health is better, more important to me than wealth. And I'm just going to say that, you know, I know the city is concerned about wealth and for Erie town to become Erie municipality to be growing and growing, but to me, what good is it to be a very wealthy town when we're the lowest?
So you would rather we negotiate a set of best management practices that protect your health, welfare, and safety?
I personally, yes. $1,000 or $10,000 doesn't do anything for the health of me or my grandchildren that come to visit. So that's my personal, I can't speak for everyone.
Do you feel these have addressed those concerns?
Do I feel that?
Do you feel these best management practices?
No, and it's 500 feet from my house, no.
My name's Heather Shea, I live in Bristol Ridge, and I would like to endorse what the prior speaker just said. Money is nothing. It's your health and it's your ability to enjoy your home. And I have not been able to do that for 5 years. And I'm speaking from experience here. When I look at this proposed agreement, I just feel that you have not taken up the opportunity to address some of the problems that have been really affecting people that live near these facilities. The noise. I'm not seeing anything different really about how you're going to handle noise, especially the C-scale noise, which is really disruptive. That's what, if you look at the complaints at the COGCC side, yeah, the odors are horrible and make you sick, but the noise, you know, and to be able to say that once an hour during the night they can wake us up and it's okay, I'm just not understanding why you have not tried to tackle that. They shouldn't be exceeding limits at all, period. They cannot exceed the limits that you have in under noise Part A. And you need to beef up the C scale. It's not okay to say they can do what the COGCC says, because that does not work. It's keeping us up. And it's going to be keeping the people at Blue Sky and at Air Park and part of Vista Ridge up again. So I really ask that you look at that. Another issue that I have, where you talk about the neighbourhood meeting, the Crestone has to handle this. Please do not allow it to be those stupid telephone call meetings. It needs to be public. We need to be able to face to people. And if you need security,
that has already been addressed in the current draft of the operator agreement at my request of the
We said that was unacceptable.
Then I had another question as to why the BOT thinks it's not okay to have the vessels well site, but it's okay to have it next to Vista Ridge and Air Park. Why are some people more important than others? That's my question.
Let me address that, because I've been in on negotiations. So when we came in, over springtime, right at the end of the election season, we had a lot of concerns from people, not just in neighborhoods right by the vessel site, but all over town having concerns of that going in and staying in the center of our town. Something that when you come into Erie, you're welcome to Erie, there's this fill site right on the side of the road. So we asked them, so the vessel site would be just east of County Line Road. We said, is any way you can move that site? Because of their agreements, I think, with mineral rights owners, if they don't drill it, they will owe mineral rights owners several millions of dollars, maybe tens of millions, I forget the exact number. So they have an obligation to extract the minerals. We started there, right? We didn't say move it closer to other residents. That's not anything we would ever have suggested. We found land that was for sale along Highway 7, 2 different locations, and we asked them to look into that. And they had their landman go out there, and they did technological and feasibility studies on the land, and the way the geometry of the land or the way it was set up, that wasn't feasible to use their site. So they did look at alternatives that the ones we asked them to were as far away from any residents as we could get, and for them still to be able to access their minerals in that section of land. And that final proposal is what they came back to and said, here's the only way we could move that site.
But you're obviously saying that that proposal is acceptable.
Well, so the original operator agreement had the vessel site in it. And so there were we had somewhat some control over that, but it did not have the Acme site in it. So that one was going to go through whatever process it's going through outside of our control. So in order to get a win, it's something that we already had some control over. We suggested removing vessels, and they said, what if we put it here? Now we don't have, because now I have to try to do gymnastics, I'm not talking about certain, because if there was a site that was not previously on the agreement, we had no control over whatsoever, we couldn't use it as a negotiating point. So we're in no way trying to say that we value one set of folks over another. We value being drilled less. And so that was the goal.
Well, Vista Ridge residents would value being drilled less too, and that's not happening. You're extending the period by adding more wells on the site that you're not allowed to discuss. And certain people will benefit, that are making these decisions, will benefit from not having a vessel well site near their home. And I actually take great exception to that. And then finally, the term 7 years plus 5. Technology is changing all the time. Why do you want to lock yourself into 7 years? Why can't you do 3? Why can't you do 5?
Our last agreement was pretty rigid. We specifically called out the technologies we wanted to use, and then technology changed, right? We were bound to technology. So we've tried to include really good language in our agreement that calls out the best technology available at the time, as well as we've added processes to allow the town to go to the Crestone and say, hey, we've heard about this technology or this fluid or this whatever that someone else is using, and we would really like you to use it in the town. And they have 10 days to respond to us with a feasibility study. They have to, in good faith, consider our request. So there is a process. I don't see them as ignoring those requests, right? Because if they're acting in good faith, and they're violating our agreement. So we try to leave it open for that. On the flip side, they are doing monthly leak detection at all of their sites. Before it was monthly for a year, and then it dropped down to, I think, quarterly, and then maybe even tapered off after that. So one, they have a set of defined sites in the agreement, so they're not going to be adding to over the term, but we're going to get ongoing air quality monitoring for that full 7 years, and they're paying for it. And that was one of the top things we heard from those engagement sessions was people are concerned about, is the air I'm breathing safe? And the only way we can tell you guys, yes, it's safe, is one, make sure there's no leaks happening, or if there are leaks, to fix them, and then two, do air quality monitoring over time and just say, hey, before drilling, after drilling, the levels are the same, right? And so that was one thing that is a win for the town, is we're going to help ensure that our air quality is safe.
And sorry, but I forgot to mention when I discussed the noise, that you're going to have the monitoring 350 feet away. Experience has told me that, you could be 1,500 feet away in the noise. The geography of area with the landfill, you could be 1,500 feet away and be kept up all night. So I'm wondering if there's something you could do about that.
So we could certainly, I'll take a note of this too, whether or not it's in the agreement, that's something the town could monitor during drilling, just like we did or attempted to do. Did we do sound? I think we did. And sound last time. So I think that's something we've all discussed about doing is more monitoring.
And I also want to add, I do feel bad for the Anthem Ranch people. They're not getting a say in this, and they're going to be affected as much as some of the area residents. And, I hope that you do have time on Tuesday where they can come and express their concerns too. Thank you.
So as we're working toward the next resident, may I ask a question of the people that were more involved in the negotiations? Were there any attempts on our side to negotiate down from the CODCC standard regulations around EDC noise in particular?
We talked about it. I think Jeff led those discussions, and I'm not remembering so much the outcome. I think that one's harder for them to control because that has a lot to do with what's in the ground versus equipment and stuff on site is what they have told us. So the GBA, they're willing to sign up to our agreements because they can control that. The GDC, from what we were told, they don't have that type of control over. So I think they're hesitant to sign up to something that they can't control. From what I remember.
From what I'm hearing from the residents and having experienced myself, it really is the DVC noise that is an issue. So let's add that to the list of asks, perhaps. Okay. Sorry to interrupt.
Not at all. I'm assuming they're not going to live at 3040 South Cherokee. So please excuse the scattershot nature of this thing. I haven't had a lot of time to prepare. It's one of the reasons that I'm concerned is that a lot of these things seem to have just come up. Perhaps I didn't hear about the survey either. So some of this stuff is just happening quickly. So we're trying to address that. Also, the Tuesday, given the nature, I'm not going to be here Tuesday, so this is going to be my only opportunity to address some of these things. So if I'm understanding correctly, effectively Crestone is using whether or not they're going to drill vessels as a leverage point with the city in order to get the OA sign?
I think it's just more about either combine that as part of it, right? But it's really just about moving forward with both sites.
The
So
city doesn't want vessels.
it's something we would prefer not, but we also don't want them to not do leak detection, right, and not do sound monitoring, et cetera. So there's a lot more we lose than just one site by not having an operator agreement.
Is one of those things also the, on the 2A applications, if I understand correctly, we're losing the ability to have public comment on that in the new way?
So in our operator agreement, what we did last time, so stepping back to the picture, right? The only thing that we can control as a municipality is doing a public hearing. And that is for the purpose of, does the application meet what is specified in our code? And our code, this frustrates everyone, including us, but it's what the state has said we can dictate is the road material, how long it is, the fence type, the fence color. So we as a board have to vote on these applications based on those criteria at a public hearing. Residents can come and share any concerns they want. And you can have legitimate concerns for health, safety, welfare, but that's not what we're voting on it. So that's what we have to offer in negotiations. Other than that, there's not much that we can give.
Is there another avenue for that? Is there another avenue if for instance, if something were to, the timeline suddenly were to increase by twice, hypothetically, near where I was going to be living? Is there somewhere that I could address and say, well, this wasn't part of the thing that I originally understood, and now suddenly the enjoyment of my house has been increased?
And you can always address us, either at a board meeting,
But
individually.
that it's do anything, correct? Unless I'm really concerned about the road trail. Is there anything?
Well,
What are you able to?
I don't know what you're asking.
So maybe I can rephrase. There is nothing in the current operator agreement that would be an enforceable clause of a violation if the drilling or completion phase that anyone had was doubled in time. We don't have any performance or benchmarks or regulations in the operator agreement around that.
You're saying the application was for the site, but not for the number of wells. The number of wells were to.
What I said before was that the BMPs apply whether there's one well on a particular site or 21.
I see.
That's the same BMPs apply for noise, for air quality, for water, everything. And you wouldn't want to negotiate it to set one set that applies to 1 to 10 wells and then another set that applies to 10 to 20 or 20 to 30.
Yeah, I mean, best practices should be.
Best practices are best practices.
But the time doesn't scale. Is there any, as someone brought up earlier, I mean, if somebody decides to come in and say, well, you apply for this location, we're now going to drill 100 wells. So now we're going to be drilling and traffic for 3 years. That's a bigger number. And we were before going to be 1 year. Is there health, safety, time in this case? It's not something that you have control over. So I guess I'm asking sort of generally, where would what do I talk to? Where do I go to say this is now over a threshold that I'm willing to do I have any way of addressing it?
So outside of what we can address in an operator agreement, right, above and beyond state law, which is that, we do it, we negotiate it, the agreement gets adopted, then it's in place, right? If you have concerns about health, safety above and beyond what's in the operator agreement, that has to go to the state, whether it's your legislators, whether it's the COGCC. It's where all this has to go, right? They are just, going above and beyond because we give them different things.
Sure. And the operator agreement is our method currently by which we can address those things. This is the thing.
Our only method.
Our only method that's going to be voted on Tuesday.
No, there are still regulations in the town code, the Unified Development Code, that govern this type of development.
Is that above and beyond the operator agreement, or is that some basic?
Well, they've been incorporated into the operator agreement. Okay. The requirements of the town's code are reflected in the BMPs that are in the operator agreement. And if the town feels that the BMPs are not being complied with, the town can go and protest, object at the COGCC hearings for a well site.
Sure, but that's only if the BMPD has been adopted into the OA. If it's not in there, there's no recourse.
Oh, no, they could go and protest and say you're at the COGCC. Under a permit type thing as opposed to one that's under an operator agreement.
So in this case, I'm just picking this one issue, there's a variety of issues there. If the period of drilling increases above, I don't know that we had recourse to do when the period was less, but now that it's increased, I'm trying to find a way to address this in some way. I'm uncomfortable with the amount of time that I'm going to be out of my home. And now that time that I just kind of got my head wrapped around is effectively been doubled. I want to know how, if I have any recourse. I feel in that I don't know who to even address. I don't know who to talk to.
The town and the state agency, COGCC and CDPHE those would be your, as well as your legislators.
And we took a note to ask them about if they'd be willing to limit, put a number on their different sites that's in the agreement. So that will be one way we can try to address that concern, and one that other people have brought up.
I mean, for a variety of reasons that I think you've already brought up, there's going to be a certain relatively small subset of residents who are going to be really adversely affected by the coming change. One of those residents, so I don't know. So, back to the original question, is the 2A applications in the new operating agreement? If I understand correctly, the old operating agreement, the 2A applications had a public comment, we could go in, we could talk. The new one does not have that provision in it.
The new one's does that as well.
It does, okay, good.
Two different things though. 2A is a state level permit, so the public can always go down to the state hearings and provide public comment. That doesn't change.
Or submit online.
Yeah, right, or submit comments online. What will not be happening for the 2 or 3 sites in the operator agreement is the public hearing for us to vote on the road and fence type. But there will be the neighborhood meetings, which will be the in-person meetings.
There's still public comment.
Yeah, and there's public.
And with the site that we're not talking about today, along Highway 7, all those public meetings are yet to happen. They still will be required to happen by that operator.
Okay. Yeah, that was one of the other.
Those all need to still happen.
The older
face-to-face, yes.
site had plans and had blueprints and. Now,
I misunderstood your question. So
do we have actually a list of what the upgrades to the OA are over the older one? Is there some? It might be nice to have some bullet points of like these are things that we received, in the new OA.
Do you want it now or do you want it between now and Tuesday? Because I have really rough notes I could stumble through, but we have 35 minutes left on the
Sure.
So what's your preference?
More than my amount of time.
No, you're fine. What's your preference? Do you want to hear it now or do you want us to somehow send it out?
It would be lovely if it was in written form, if it could be in written form, and just I'm sure we can figure out a way to get it.
Are you on then? So you didn't get notifications of our survey. We can maybe show people at the very end of how to send them notify me too.
Yeah, if you go to www.eerico.gov and then you type oil and gas into the search, there's an oil and gas page that actually has the most recent draft operator agreement as of Friday. It has the BMPs. It has the summary of what we're getting in this operator agreement that is new or updated. And it has how you can get added to notify me is specific to oil and gas. It also has oil and gas maps, any activity, any plug and abandon notices that we get, we'll put that all in that same location as soon as we get them.
And I just wanted to remind everyone, including you said you would be able to make the meeting Tuesday, that you can always email. So after you get this information, if you you have other thoughts, questions, concerns, please make sure you email us before that too.
And we did set up a specific, you can email the Board of Trustees at any time, but you can also email Erie Oil and Gas at erieco.gov. And what we're going to do is continue to collect all of those emails that are oil and gas specific and get those to all of our Board of Trustees. That way there's an avenue for them to have all the same information and capture all information that comes in via residents or to one of the individuals' points, maybe neighbors that aren't residents that want to provide comment and make sure it gets to the Board of Trustees.
Is there any teeth to any of that, or are we, when we're asking these things, when we bring these things up in the public comment, does it make us feel good, or is there any actual?
I mean, I don't know, I guess that's why the Board of Trustees has done multiple sessions with citizens in a variety of ways. I don't want to speak for the Board of Trustees. That's up to them.
And when you say chief, like, when I hear that question, my mind instantly goes to all of our BMPs will get submitted with their applications to the state, and then they're attached to the permit. So if they're in violation of those, there's teeth to that, right? What they're setting up for, they're obligated to meet, and either the state will enforce it or we will, depending on their.
I think it's pretty pragmatic more to do with things that we can control here, setbacks, where on the plot of land the wells will be drilled, that sort of thing.
We would love to have control over that.
Yeah. Okay. I also wanted to ask, is the OA the proper place to address the low bond per pad?
The low what?
The bond for the completion. I mean, I hope to be still living here in 30 years, and I'm a little worried about that.
So I can answer that based on a document that Sullivan Green prepared in September, that the town cannot enforce additional bonding above and beyond what the state requires. Is that correct?
That is correct. Unfortunately, in this instance.
And we all recognize that bond is incredibly low.
Yeah.
Tim, can I ask sort of question here? Are we going to have to be cut off at 4 o'clock? Because there's a lot of people.
Yeah, I'll get out of the way. Thank you for your time.
Thank you.
I'll make mine quick. Most people have hit it. I'm Mike Ronald. I'm here at Erie Park. Yeah, you go through all the things before you buy a home and what that piece of property is going to be and what that piece of property could be. And unbeknownst to us, we now have a major industrial factory sitting on our backyard. That's frustrating. And I understand you guys are just the conduit to take it and we can go to our state. That's frustrating too. I'm not sure that any of this makes a lot of sense, but yeah, the noise, if there's anything you can do in the operating agreement, noise is huge. They put one of these in not too bad, far from, I run an industrial type business, big stamping machine. We make lots of noise. That thing can drown out 260 tons of noise. That's a lot of noise. And like Tim brought up, there's got to be a time frame. We know this is going to happen. One well, I watched them put it in and out in 60 days. Okay, I can live with that. 15, efficiencies are going to get better, you're going to do it faster. How many ever you can put in? 100? How long is that? And then one of my biggest concerns is the future. With all the things that are going on, and horizontal drilling they're getting better at it every time. Who says they can't come back into a well site that has 15 to 30 holes in it and go in and go another 30 miles, whichever way that goes. And then we are in an industrial zone again until that well is done. I know these are none of you guys, you can't fix these problems, but there are issues that I see in the future. Yeah, we could have lived with a certain amount of time and it may have made a little buffer between something and something else. The money, yeah, we don't want the money. That's no big deal. Don't give us the money, plot a bunch of trees, please don't block Tim's view, but put a bunch of trees so we don't have to see the stupid pipes and tanks. If 10,000 going to invest in anything, invest in making it go away or hide as best you can.
So can I interrupt you there to address that? Can I interrupt you there to address that?
Sure.
So that's something we didn't have in the last agreement, and that we do have in this. So they're required to do landscaping berms,
Right.
or like dirt berms, some sort of berm, and they're gonna submit it to the city and our town, and again, we'll have approval and insight, because we heard that from a lot of residents too, is we don't wanna see this stuff, so, that'll be something that we will do. I know it's not a lot, but it's something, so.
And like I said, I think the biggest fear we have is noise. And
Yeah.
the fact that you can't build a house after a certain amount of time, I mean, your construction people have to shut off at a certain time. These guys go 365 days a year, 24 hours a day, it doesn't stop.
Would it be correct that your orders of priority for us would be to address noise and then odor and then the visual impact?
Hi, my name's Sarah Rummel, and I live at 276 Skylands. So the decision on Tuesday, I'm just curious if you all feel like this is a rush decision,
Yes.
and do you think that's in the best interest of the people who live here in Erie?
No.
Make a rush decision?
But, you know, we've
But there's
discussed that a little bit
reasons.
up here, and you can see we're in between a rock and a hard place, like Jen said. We're having our feet held to the fire. So
Yeah.
I don't, one of the drawbacks of that, like, is potentially we could reject the entire thing, and then you can see where that would lead us. So, I was gonna do this at the end, but can I take a moment right now and ask the audience, by show of hands, who would rather allow vessels to be drilled in order to reduce the number of wells at the site that shall not be named, knowing that it will reduce developable property on a primary ingress road and have a completely second or additional well path? By show of hands, who would rather allow vessels to be drilled in order to reduce the number of wells?
Ridiculous. Yeah, that makes us a jerk. We actually wanted to. What answer did you expect to get from that?
I expect to ask, is this operator agreement better than not having an operator?
Do I want my children poisoned by benzene or killed in an explosion?
You can understand where we're at. What I'm trying to show is that we have a really tough decision here to make. And we would like to represent you properly.
I mean, I have to say that having
Maybe we shouldn't have gone there yet. Let's finish public comment or question for everyone. We got these documents last Thursday, so we'll have had them for a week and a half before we vote on them. I think a week and a half is enough time for us to review and understand the document. Getting your feedback right now, we're gonna have a couple of days to go back to Crestone and ask for a couple more things. They understood that was a possibility. We told everyone to hear from residents, so we're either gonna get somewhere or not, right? And that will determine how we move forward.
So how long have they or who created the agreement, and how long have they been being created, and you're just seeing them, so?
We've seen the final document. So yeah, we've been negotiating for several months. Our attorneys work with their attorneys to create the document. So in the negotiation sessions, we kind of focused on high level. Here are the things we want to solve, and then we let the attorneys do the verbiage behind that.
Sure, so did you all know that it was going to be November 1st, that this was going to be a tight timeline, and why haven't we heard about this like sooner than now, and there's such fear in a week to try to make this decision? Why haven't people been learning about this or hearing about these, being involved in this?
Right. So, like I said at the beginning, Jeff was one of the other negotiators. He remembers that date being mentioned, I don't. So all I can say is sorry that got lost somewhere, right? So we're trying to do,
yeah, on all of our help and our input. I mean, I'm sorry, but
sorry I forgot the date, right? But we knew that we were negotiating an agreement that was going to have to get reviewed and voted on at some point. And our moratorium expires, I believe, at the end of this year. So we knew we were coming close to the end anyway. We're not voting on something that needs weeks and weeks of work still, in our opinion, right? We've gone as far as we feel we can come before getting public engagement.
How many people live in Erie?
27-ish thousand.
So do you all feel like 400 people plus 20, 30 people are representative of Erie and what people think about this decision?
This is I don't like this number, right, because I'm a really engaged citizen. This is one of the highest numbers we've gotten for any sort of topic that I've seen over the years. So unfortunately, our level of engagement from residents is not high. And getting a couple hundred people out is a big showing of our residents. So we try our best to inform you guys and talk to you and engage with you, but we can't control your engagement.
You said that you were afraid of two different agreements. Can you say what you mean there?
What do you mean afraid?
I think you said that you were worried that that there was going to be two different applications.
So what they've said, to meet their deadlines, they have to move forward with a plan, right? And that's either the plan that's in this operator agreement, or that's their original plan without an operator agreement, without any of our BMPs, etc. So I believe them that they're going to move forward because they put everything on hold in May so we could negotiate. We have been negotiating since July, maybe June, July. So we've all been working with Faith, spending a lot of time to get to where we're at. So I believe them that next Wednesday they're going to pursue one path, right, no matter what we do.
And what happens if they pursue that? Then do they need to get applications to be able to do that?
So they've already started the process. So they're going to be continuing the state process for one or two plans, right? It's just, is the state laws and regulations, are those the only things governing them? Or is this document going to govern them, which is above and beyond what the state requires?
Sure, and so if they get their application going, does ERA have an opportunity to vote on that or to make an input on the application?
So we don't ever vote to the state. As a stakeholder, we can provide comments as a part of the process, and I think in the past couple of years we've done a really good job at providing comments at COGCC on all applications in and around here.
Okay, thank you.
Just to clarify, the project that shall not be named has not been approved by ERA yet, just on the question that Sarah just asked. I also just had a couple of clarifications. So we've been talking about the BMPs a lot, and that same project is accepted from a number of those BMPs. So I just want to make sure that's known.
So let me state that as a question. Would a site submitted to the town under a Type B process be exempt from any of the BMPs or agreements of this operator agreement with Crestone Human Resources?
No, because a number of the BMPs in this proposed agreement come from the town's code, and the development would have to satisfy those requirements in order to get the Type B permit.
But there's more BMPs in this document than what's in our Type B.
Yes.
That's the question. So there are things
Yes.
that are in here that are not going to be upheld in a Type B application.
That's right, and that is one of the big pluses of this agreement. It is a voluntary agreement, and they're agreeing to more than they have to do.
Can you give just one example?
Go to my long list for you.
So a number of the BMPs in this document say, with the exception of the identified wells. That's what I'm referring to. So it has the BMP list, but then there are exceptions.
I think that was for our regular public hearing process that we're waiving for the sites in the operator agreement. All the BMPs will be in effect at every site that's identified here.
Okay, that's
no question.
Super confusing to me, including follow-up questions I've asked to some of you. But okay, I'll hold on that. I think what I want to focus on a couple of things. The main one, and Liz talked about this some as well, is that I don't think that this was intentional, but there has been sort of a cluster of a process here. And it has to do with the combination of a legislative process and a quasi-judicial process smushed together. And the effect of that is that the residents have not been able to communicate throughout much of this process if at all, partly because of the part of it that is quasi-judicial. So we have that going on. At the same time that, in fact, you all, two of you in particular, if I get that correctly, have been talking to Crestone about that same quasi-judicial project, as evidenced by the fact that it is now in a new contract, so necessarily that was part of some communication. And then the town, when I came by, they had said, Farrell, it was you, but I don't know if that's actually true, but the town then told leadership in Broomfield that that the staff could not talk about that project. So from a number of different angles, we've had this sort of confusion from your side that has kept people from speaking and kept people from participating in the process. Colorado Constitution for a legislative process requires due process, requires public open forum. This doesn't count. And I appreciate the gesture to have neighborhood meetings after the project is approved. But I think the actual weight of neighborhood meetings is that they happen before a project is approved. And so to me, that doesn't satisfy the need. And I also would ask the question of whether it satisfies the law to not have public open forum until after the project is approved, which would potentially happen Tuesday. And then those forums would happen. That seems like the wrong order to me. I also want to point out that, and this relates to what Tim said, my understanding, again, of the operator agreement is that it does give away the town's ability to call a hearing for applications 2 and 2A of the COGCC. And so if the OA is passed, then for those projects, we would not have the option to go and testify at the COGCC because we would not have the option to ask you all to call a hearing, which before this operator agreement is passed, if that happens, was a possibility and was something that we had sort of hypothetical agreements about doing. I also, and this is my last thing, if this is not approved, the OA is not approved on Tuesday. And then Crestone goes to the COGCC for the one project that has been approved by the town and the one project that has not been approved by the town. You all do have the option to request a hearing for both of those. So now we're extended another month. Okay, so for both of them. So that's a possibility that we could do that. And when we're talking about current state law, and you all very well know my position on this, Martinez is current state law. And that is true because that is the current ruling. It being under appeal does not mean that that ruling is not law right now. If that feels fishy to you, because other folks are not upholding that, and I understand that being complex, then wait until the Martinez ruling comes back. Because as you all know, oral arguments were heard. So it's like 2 months or something. So delay Tuesday, give us more time. Allow them to go and put these applications in, request a hearing which will delay it more, and we'll get closer to knowing what the Martinez decision is, which gives you power, Jen, that you say you don't have. You could. We just have to wait a little bit. And I get the hands tied, but there's so much at stake. Just wait a little. Give us more time to actually process this thing and see what might happen if we wait for Martinez. It's a possibility.
So, John, in the current operator agreement that we have right now, sorry, no, in the operator agreement that we are already under with Crestone,
2015 agreement.
Yeah, the previous one. Does that preclude our ability to request a hearing for a site for the vessel site, which is already in that agreement? If we went down the path that was about
The vessel site would be governed according to the 2015 agreement. It would be subject to those requirements as opposed to a type B type process.
So we would not have the ability to request a hearing and slow down the process on that.
No.
And I'm trying to play out what Ms. Butler just.
You would potentially, the town could end up being in breach of the 2015 agreement if it doesn't follow that agreement with respect to the vessel site. Does that answer?
That's what I was asking.
Okay.
I'm just going to take on follow-up. My understanding of both like the 112 initiative and Martinez ruling is those would, if Martinez is upheld and 112 passes, those apply then to sites that are submitted after the decisions are made, right? Not in process? Or did, you know, if the Martinez ruling is upheld, does it apply then to every single site in process or just new sites?
It applies prospectively,
Okay.
not retrospectively.
So only to new sites that haven't started the process.
What some people have been concerned about with the Martinez decision is it will force the COGCC to go back and reevaluate a bunch of permits it's already issued to see if they are consistent with the public safety, health, welfare, and protection of the environment. And that's the concern that the industry has expressed about it as well the way the statute is interpreted.
No, I was just gonna say, you mentioned it, I noticed a few people.
So about 15 minutes, so we're getting happy to this. Does anyone else want to speak? It's not row. So if anyone wants to come speak, come speak first, so I can try to manage time.
I'm Brian Sir. Speak quickly. I'll try. I'm Brian Goodnar from 280 Skyline Drive. I'd like to ask you to consider the uniqueness of the potential developments and how this oil and gas development, I believe, poses a unique threat to the citizens' health and safety. And when it comes right down to it, protecting the citizens' health and safety has to be your primary goal in all this. And I know you feel squeezed, but there's some special things that I think need to be included in any operating agreement that you should agree to. In 2013, the state of Colorado completed a multi-phase project shoring up Bonanza Drive because of the shallow mines in Erie, especially in our part of Erie, are subsiding on their own. You know, it's not based on any kind of a seismic activity caused by fracking. They're already caving in. So after drilling holes along Bonanza Drive and pumping yard after yard of concrete, they finally filled up that void underneath Bonanza. But that shallow mine exists in many places in Erie. So you've got the fracking activity, which by design is causing explosions underneath these mines. In some cases are just 60 feet deep, that have proven that they are subsiding. They tend to subside. Now, the experts that you cite in your operating agreement do not include the Colorado Geological Survey, which they are responsible for the abandoned mine program. They're responsible for putting together subsidence maps. Was there a reason why they were not consulted? Why they're not part of the experts that you used?
That would be state jurisdiction. So that's the answer.
I would say that protecting your citizens' health and safety
is not just a state matter, it's a local responsibility.
The agreement that we're here about today does contain a BMP and a submittal requirement for a geologic report.
Okay,
It's just that the question you're asking is presupposing something, and we don't know yet, because we don't know what they've submitted for the Acme site or what that report will say. At that point in time, the town can then refer it out to the Colorado Geologic Survey for their comment. They have that right under this agreement. They have that right under their Type E permit process.
The oil and gas industry would tell you that fracking itself does not cause earthquakes, but that is not true. In fact, there was a two well drill pad shut down this very week because of earthquakes that were caused in Lancaster, England. And England has been reluctant because for a lot of reasons to do fracking, but they turned it on again. And in the course of 9 days, they had 17 earthquakes caused by that drilling operation. And the 17th occurrence tripped a threshold that they had defined in their best management practices that said, if you get to this level, it is a red activity and must be, drilling must stop. Now, here we are sitting over abandoned coal mines, and there is nothing in here in the BMPs that say that a certain level of seismic activity would create a red event for these pads. I don't know why in the world we wouldn't insist on that. Is there a reason? I mean, if other locations have that as a BMP, why wouldn't we when we know we have problems with subsidence?
We should go add it to the list, and we'll look at any of the BMPs in the operator agreements of neighboring municipalities, or whether it's Pennsylvania or King County. We'll see what we can figure out.
My second point is with traffic, the configuration that shows that they're going to be exiting onto Bonanza and presumably turning right towards Highway 7, that intersection has been screwed up since it was first put in. And the extra lane that was put in a couple years ago didn't fix anything. And we're adding all this extra traffic. This development plan better include more than just having them use the right kind of gravel on their access road to Bonanza.
I know, the town just approved some sort of replatting or something out there so we could do road improvements at Highway 7 Bonanza. Do we have that specifically planned yet, or is that?
Well, you adopted an easement, so we had that. But I think once that traffic plan comes in, then we can make recommendations. That staff are definitely concerned about that as well.
Well, traffic engineering defines the quality traffic flow by level of service. And there's no reason why the town can't say that your traffic management plan needs to satisfy a level of service B. You know, right now it's probably like an F. You know, I don't know why you're going to add this major industrial traffic flow to an already screwed up road system unless you're going to have them at least maintain the crap that we have already. My last point is, I think Erie is the perfect place for somebody to stand up against the oil and gas industry's pressures that you're under. Their budget to defeat 112 was 20% more than Erie's annual budget altogether, which I think puts you in a perfect position because there's only so much blood in that turnip. You know, they could, you know, probably easily bankrupt the town, but we're small enough to rebound quickly, where if they were to take on Boulder or other places, you know, it would be a much bigger deal. I think you're in a perfect position to stand up against that pressure if you can. That's all I have.
Thank you.
Hurry through the rest of you. Getting really close to
Someone
4
dial that
o'clock.
clock back about 12 minutes.
I'm Pamela Nocerino, and I'm at 3040 Cherokee Court, sort of, the bottom, haven't moved in yet. Our house butts up against the land proposed, or who must not be named property. So I was just going to ask a couple of things. One, is Crestone motivated to threaten us with a November 1st deadline because of the election in any way, or is it irrelevant?
Our understanding is they've already started the state process for both sites, so if 112 passes, it's not going to impact either of those sites.
So neither 112 nor 74 would impact what they do on November 1st.
74 could hurt us if we push back on them and that passes. But 112, from our understanding, would not impact those two sites.
Okay, so it is irrelevant to their urgency. Okay.
Yeah, that was the first thing that popped into our minds.
Yeah.
Yeah.
Just wondered, it seemed irrelevant because it didn't apply, but it's worth asking and people were wondering. So, and Adam, I just want to say that I'm sure it's a really awkward position, you know, when you ask us, I'm a teacher, so when you ask co-group questions, you know, we have all kinds of criteria for what makes people comfortable or uncomfortable in those situations. And I just want to say that I'm sure it's a very uncomfortable situation to be considered the Goliath of this event. And it's very confusing when you're in fear to know who is the Goliath when you're a finger on David, you know? And it can confuse us. Is it the oil and gas? Is it this operator agreement? Is it the lawyers? Is it our board of trustees? We voted to protect us. And I just want to acknowledge that it's a really hard situation for everyone. And it's really difficult to separate your own personal experience. Like, we can't move in. And now maybe for a lot longer. So separating the personal experience from the group, I have to request you don't vote on Tuesday so we can review and add some of the important points that people have brought up. And second, to address the air quality language in the actual operating agreement, which is, it says that they won't, gas produced during the production will be captured and not flared or vented to the maximum extent practicable. And I don't know what that means. So I would love like cutoffs and timeframes in the monitoring, the monthly monitoring. What happens if it's too high? What is the emergency response to that? Speaking as a person with asthma already and a 1-year-old granddaughter, I would like to know what happens when those exceed, whether it's the COGC limits or our Erie limits or our own research limits for what's happening for us. So I would ask for those two things, is the delay on the vote on Tuesday and then more clarity in the language as to what happens with the monitoring. And I appreciate the more frequent monitoring as one of the best practices we're insisting on.
My name is Ashraf Sheikh. I'm an Erie Highlands resident. And I just had some hopefully quick questions, but for the operating agreement as it's being written, does it govern all of Crestone's in-process and future drilling operations?
I would say yes, because we're adding on to our old agreement, and there are, I believe there's one site out by I-25 that's in process that was in the old agreement.
So
everything that's on the map,
okay.
and it's in our town planning area. They've identified sites that are upcoming, and those are in there.
For example, does not include the Pratt nor Waste Connections pads.
Because those have already been drilled.
Except for the possibility of re-entry.
So it does govern if they want to re-enter that way.
I don't see that in the operator agreement.
Well, there's a couple of things. If there's a pad site that's not identified in this operator agreement that Crestone decides they want to develop in year 6, that pad site can be processed under the town's existing oil and gas regulations in the development code.
And not under.
And not under this agreement unless the parties agree to amend this agreement to include it, that's one of the things that's happening with this proposed agreement now.
Is to expand that, to cover.
No, well, there's another well site that isn't subject to it.
So this would bring that well site
Under this agreement, that's as it's drafted.
and the additional.
It's the one that's not to be named.
Okay. And if the OA does not get signed, it doesn't preclude expansion of pre-existing well sites or anything like that, does it?
That would be up to them applying to the state.
And we would have no say in whether those additional drill sites would have to do additional air monitoring.
Right.
So I noticed that one of the changes was that town has a right to conduct inspections of well pad sites. What are what form will those inspections take, and what can we do as a result of what we consider failed inspections?
So I think our envisioning there was that we wouldn't actually have a staff member doing that, we have a consultant. So there's concerns that there may be a leak at a particular site, whether that's something somebody smells or sees. We call in our consultant and have them come out and do an inspection. And we have to notify Crestone within 48 hours of our findings. So if they're in violation of something in our agreement, then we'll bring that to their attention, right, and go through the process we've outlined. And I wouldn't call it a dispute, right, unless they disputed it.
But also beyond that, of course, any complaint filed with the COGCC may have a field inspector on their schedule and with their pre-existing agreements
Since you
with
did say we're
operators to
going
go
to try to
inspect.
get like experts, right?
Yeah, we're going to get someone that knows what they're doing and has
If they find something that violates like a state level COGCC requirement, they'd be able to file that up the chain as well.
We will definitely do that, because we did that with some of our data, I think with our sound and air quality before, so we'll provide everything we have to the state in that type of situation.
Okay, so we can inspect whenever we want to make sure that they're abiding by our town rules, the operating agreement. And if anything is found during those inspections that violate any other thing that aren't specifically laid out in the town rules, we
You move it up, we can't enforce state law,
right,
yeah, but
we can run it up the
yeah,
chain and
we
file
can
it.
run it up the chain.
And coming from an expert consultant, it would have. some-
Better than just a random person with some equipment out there monitoring.
Okay. And that's it. Thank you.
Thank you.
From the organizers and those in the room, may we have a gentle person's agreement that each of the two remaining folks get 5 minutes apiece? Is that okay? Okay.
David Lawton in Old Town. So continuing the last question, I didn't catch on the inspections, does that require a day's notice, or you can just stroll out there anytime and get an inspection?
If we know we're going to go out there, they ask for a heads up, but if it's some sort of emergency or you're smelling it right now, we're going to get someone out there as soon as possible.
I understand COGCC gives them 24 hours or something like that when you notice when they come out to do inspection, which seems ridiculous.
I don't know.
We're coming out to see if you're violating, we're giving you 24 hours notice.
Right.
Clean up your act, so we can go out there anytime. In reading the OA, it talks about best management practices, BMPs. I'm not familiar with those. Who writes those? Where are they? Are they reviewed? Are those written by industry?
So I will say that the list of BMPs that are attached as an appendix to this operator agreement started out, I would say they're about 80% mirroring what Crestone agreed to as BMPs with the city of Tacoma. And the negotiation tactic there being that if Crestone already agreed to these BMPs in Tacoma, why couldn't they agree to the same BMPs across I-25 in Erie? So that, like, there are verbatim, would you say it's about 80%? Yeah. Right. But would you say it's about, I don't know, a majority of those are actually verbatim, word for word, taken from the BMPs from Tacoma. town staff and Jennifer and Jeff also looked at regulations in Boulder County, in Broomfield, and those are the major municipalities, and also got input from representatives from the consultant firm that we've engaged with, from the COGCC, and representatives from the CDPHE. That's how this draft list of BMPs were drafted.
And it's on the website, it's another, there's 3.
They are documented, written down. It's not just the operator saying, yeah, this is the best we can do.
Yeah, and we have a Carol has some copies of them.
Okay, and I'm just curious as to who are they written by and who's reviewed them and.
So our attorneys.
Well, I mean, professionals. I mean, the professionals in the field, are these really the best practices out there? And have they been peer reviewed, et cetera?
Generally, yes.
All the agencies he listed were helping us with our best management practice, our operator agreement, the odor management plan, right? We pulled in as many experts as we could, so we weren't questioning our own knowledge, right? Because we're not experts in oil and gas.
That's basically my question. Were there really experts that wrote these and
reviewed them, right, and provided feedback?
Generated them and not just oil and gas operators saying these are the best things, best practices. So, okay, that's all my question. Thanks.
I'm Bob Frazier, and I don't have a lot of time, but everybody has said pretty much, what I would have wanted to say, but much better. And I just wanted to make sure I had time just to say that I do feel that this has been rushed. I just found out last week, here we have a meeting on a Saturday. We had to come in, you were talking about people were worried about getting bullied, and so you set up these other meetings, and I just thought this was kind of weird. You had to come in, register, go through, get wanted and all of that. But I just feel that this has been really rushed. I have other friends that would have came, but on a Saturday afternoon, they don't have time. They didn't have time to come in. We did not see public comment on the agenda for Tuesday. But I hope that you do not do the vote, or give everybody the chance to come in and talk. I hope the vote is postponed. Everyone's given due process as they should get. And I just wanted to say that I do value health over the wealth of the town.
Okay, so we will wrap up. Thank you guys for coming and providing your feedback to us. A lot of notes.
As a kind of a final comment, please, if you go to erieco.gov, under the transparency menu, go to the oil and gas item. The current draft, which includes those 3 amendments that we talked about earlier, has been posted. The list of BMPs has been posted. The results of the oil and gas survey has been posted, as well as the email address, erieoilandgas@erieco.gov, is the next available opportunity for you between now and Tuesday to submit feedback about this operator agreement. You can always send email to bot@erieco.gov, as long as it doesn't directly reference a quasi-judicial matter. Beyond that, we will have public comment as an item added to the agenda on Tuesday with a specific start time, and that will be another opportunity for comment.
I heard that there seems to be a desire to slow this down or pause it a little bit, so we haven't had time to discuss that, so let us do that. But as of now, with it being on the agenda, we promise public comment would be added at the same time.
I just say thank you all for coming. Please spread the word to people that you know that have other concerns so that we can get this input. This is something that is very valuable to us. As rushed as it does seem, obviously we don't like the timing, you don't like the timing, but this is something that can benefit us greatly. The more input we get, the better it can be.
And for myself, I'm willing to say I'm willing to meet with anybody, within a certain amount of with some notice, I would be willing to meet with you and to discuss this one-on-one at any time that is convenient for both of us. And I know it's a rush.